You ready yet?
Yep.
All right, today is Monday, June 17, 2024. It's 10 o'clock a.m., and I'm calling to order our regular commission meeting for the State Ethics Commission. It looks like we've got an agenda in front of us that have 12 parts. Has everyone had an opportunity to review the agenda? All right. Staff, are there any changes to note at this point in time with respect to the agenda?
Yes, preliminary hearings. B, matter Nicole Jones, that's being continued. She sent in a conflict notice. She's being called into criminal trial. Additionally, she on Friday provided me records that I'd requested, so I'll have an opportunity to review those as well. Anticipate that going on the next meeting.
Okay.
And item D of the same section, in the matter of Craig Owens, I have a consent order, so that would just be moved down to the.
Retitle that T.
Yes, so case number 23-0048-C in the matter of Craig Owens is going to be now listed as 4T on the agenda. Is there anything else from the staff with respect to the agenda? Any commissioners? All right, I'll go ahead and make a motion that we adopt the agenda as amended.
Second?
Got a motion and a second. Any discussion? Go ahead and call the question. All in favor say aye. Aye.
Aye.
Any opposed? All right. We will go ahead and move on to item number 2 on the agenda, which is the review and approval of the meeting minutes for the March 18, 2024 regular commission meeting. Have all of the commissioners had an opportunity to review the minutes from our meeting in March? All right. Is there any discussion that any commissioner would like to have with respect to any of the items on the agenda? I will go ahead and say for the record, because I had asked staff about this earlier today on page 2, under the preliminary hearings from the last meeting, this was in the Brad Barnes matter. So apparently what happened there, and the reason that there are 2 motions reflected, is that initially I made the motion to table the case until after the next preliminary hearing. There was further discussion that took place in that regard, and then another motion was actually made to continue the case until the next regular commission meeting, which would have been today. So if there's any confusion with respect to those items, I take full blame for calling for 2 motions with respect to the same case. So with that point having been addressed, do I have a motion with respect to the review and approval of those?
Motion to approve the minutes?
I got a motion, a second.
Second.
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? All right, so those have been approved. We will now go ahead and move on to item number 3 on the agenda, which is the preliminary hearings. We're going to have 2 preliminary hearings at this point in time. It'll be what is reflected on the agenda as 3A and then as 3C. We're going to go ahead and start with preliminary hearing 3A, which is case number 24-0014-C in the matter of Tammy Andrus. Is there anyone here on behalf of Ms. Andrus?
I don't see her, sir.
Okay. All right, go ahead and proceed.
Okay. Good morning, Mr. Chairman and Commissioner members. This is the matter of Tammy Andrus, case 24-0014C. This was a complaint that was initiated after an office-wide audit. Ms. Andrus was a candidate for Cobb County Board of Education back in the 2020 election cycle. She filed her DOI on February 18th, 2020. She was the unsuccessful candidate in that primary election. She did successfully file the DOI. She successfully filed her first 3 CCDRs. Her final CCDR that she filed was the September 30th, 2020 CCDR. On it, she showed a balance of $974 and some change. Thereafter, she didn't file any CCDRs. Also, on her initial CCDR, the April 30th, 2020 CCDR, she reported just over $1,000 in pre-DOI contributions, and she reported spending $119.95 in campaign expenditures. That's just the background information. Notice She registered an address on Thunder Way Road in Marietta, Georgia, back in 2020. That was a good address. We served the complaint on her back in January of 2024 at that address. She did respond. It was in March 2024, just before the last board meeting, but she did receive the complaint. She received notice for the March board meeting, which her case was originally scheduled for. Once I heard from her, looked like it was something we could work out, and we moved to today's date. She did respond. There was some documentation I asked for her, and she responded with part of it, but then at some point within the last 4 to 6 weeks, we just lost all contact with her. She did receive notice of this hearing date back on May 7th, and the UPS record that we received, there was a notation that the carrier met the customer. So she did have notice of this complaint. She did have notice of this hearing date. The violations that we'll be presenting to the board today, there's 6 violations, 2 violations of 21-534C2A. She failed to file the October 25th, 2020 CCDR and the December 31st, 2020 CCDR. Violations 3, 4, and 5, those are the supplemental CCDRs that are required by December 31st at the end of the year, as long as the campaign account remains active. And then lastly, the 6th violation is a violation of 21-530G, and that's for receiving pre-DOI contributions. The law in this respect, OCGA 21-534C2A, this is just the law that provides that candidates for office, once they file the DOI, they have 6 reporting periods throughout the election year: January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st. OCGA 21-534I2, this applies to unsuccessful candidates for office. If they don't terminate their account, they're required to file a supplemental CCDR on December 31st of each year while the account is opened. And lastly, 21-530G, this is the prohibition on pre-DOI contributions. The evidence that we're relying on to substantiate these violations, this is the filing history printout. This was from the Cobb County Easy Vote system, and it shows that she did file the DOI. It shows the 3 CCDRs that she successfully filed, and that's the extent of her filings. So thereafter, September 30th, 2020, there was no filing activity. I did also talk with somebody from the local Board of Elections just to make sure that this was accurate, and they confirmed they didn't have any other filings showing. Additionally, this is the September 30th, 2020 CCDR, and you can just see that this is the last CCDR that she filed. She was still showing a balance of $974 in her campaign account. The individual pre-DOI contributions, there was a dozen or so contributions and a couple of expenditures. These are just copy and pasted from the CCDR that she filed for the April 30th reporting period. But simply anything she reported prior to filing the DOI, I copied and pasted here and, tallied all of these up. And you can check and see, all these predate the February 18th, 2020 DOI that she filed. And the math was done. I did it several times just to make sure the numbers were accurate. But these are all just copy and pasted transactions, pre-DOI transactions that she reported. And so we'll be asking the board to find reasonable grounds on the following 6 violations. Again, there's 2 violations of 21-534C2A for failing to file her October 25th, 2020 and December 31st, 2020 election year CCDRs. Violations 3, 4, and 5 are violations of 21-534I2, and that's for failing to file the supplemental CCDRs December 31st, 2021, 22, and 23. And then lastly, OCGA 21-530G, she received $1,041.62 in campaign contributions, and she expended $119.95 in campaign funds prior to filing a DOI with the commission.
Does staff have, excuse me, did the commissioners have any questions for Mr. Baywell?
What's the limitations of action, the statute of limitations?
It's a 5-year statute of limitations in this case.
Because it's a 4-year office?
Was a 4-year office, yes, sir.
Any other questions for the staff?
So if she had properly closed her account, we wouldn't even be dealing with charges 3, 4, and 5.
Correct.
It's because she just walked away. I mean,
Correct.
okay.
It-
What are we going to continue to do then? As long as she leaves it open, is she going to continue to appear on our calendars?
We could do that. This was a pretty, this wasn't an egregious case. I tried to be reasonable with her. This was something that was probably fixable in a matter of getting her bank records and, amending a report or backfiling a couple reports. We're probably looking at maybe 2 hours worth of work to fix this. And initially, when I talked to her, it seemed like something we could pretty easily work out. We were probably in speeding ticket category.
But to the chairman's point, it won't keep coming back on the agenda because we'd have to keep refiling the allegations. Is that true? We'd have to reopen the case.
But I think we would have to, so that we didn't, we have to go ahead and act on what's here so that we can keep it
Right.
within the 5 years.
Yeah.
I mean, excuse me,
I agree with that.
the 5 years.
I think we need to act on what's here so we don't lose any violations of the law through the statute.
Right.
I think future violations are out there. But I think that also is contingent on there still be money in the bank account. And that's something that down the line may not be the case, in which case that would resolve that issue.
And I can let the commissioners know, I did ultimately subpoena the bank records. I received those back the last week in May. I had some personal leave time, so I was out of the office. I couldn't, for all intents and purposes, she should have terminated at the September 30th reporting date. That's when her account was zeroed out.
Oh, so it has been zeroed out.
The account has been zeroed out, yes.
Do we know where the money went?
I didn't comb through the records in great detail just because when I got back to the office, it was just last week, and we were within a window to where I couldn't amend the complaint, but it was not the $974. It looked like a lot of it was just in-kind expenditures.
This is
Meaning,
going to be.
it was nothing big. It did appear just by looking at the statement that it was campaign-related. And it's just something that she probably could have reported as a in-kind expenditure.
Well, again, this is going to be like a case that, a fairly recent case that we handled in Savannah. Whereas, we go ahead and act on what's here, and it certainly doesn't, judicially a stop or anything else with respect to making new allegations, going forward that we just learn about. So I know that you had a different position on that point in Savannah, but, again, I think that, that especially since we're talking about, actions that go back to 2020 in this matter, that we definitely need to act on, what's been presented to us at this point.
I think it would
That's
be-
my thought.
Everyone's hope this would smoke her out
Yep.
and get this,
Resolved.
come back with a consent order next
Right.
time.
Right.
I'm
But we may,
hoping when-
I don't know that we have much choice, given that she's not responding to,
We can't just hope that she's going to come out of the, out of the shell. So, I think that, again, this is just my opinion. I think we need to go ahead and act on what's been presented to us. Any other questions for Mr. Baywell, or other staff? All right, I'll go ahead and begin making some motions on this. I'm going to make a motion that we find that reasonable grounds exist, that there was a violation of OCGA 21-5-34C2A by virtue of the candidate failing to file her October 25th, 2022 election year CCDR. Do I have a second?
Second?
I got a motion and a second. Do we have any discussion? Go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? All right. Go ahead and make a motion that we find that the reasonable grounds exist that the respondent violated OCGA 21-5-34C2A by failing to file her December 31, 2020 election year CCDR. Got a motion. Is there a second?
Second?
Got a motion and a second. Any discussion? I'll go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? I'll make a third motion in this case, that the respondent, that there are reasonable grounds to believe that the respondent violated OCGA 21-5-34I2 by failing to file her December 31, 2021 supplemental CCCDR. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? I'm going to go ahead and make a fourth motion in this case, that reasonable grounds exist, that the respondent violated OCGA 21-5-34I2 by failing to file her December 31, 2022 supplemental CCDR. I got a motion. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? Motion passes. I'm going to go ahead and make my fifth motion in this case, that there are reasonable grounds exist that the respondent violated OCGA 21-5-34I2 by failing to file her December 31, 2023 supplemental CCDR. I've got a motion. Is there a second?
Second?
Got a motion and a second. Is there any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye. Aye. Any opposed? Motion passes. I'm going to go ahead and make my last motion in this case, number 6, that reasonable grounds exist that the respondent violated OCGA 21-5-30G by receiving $1,041.62 in campaign contributions and expending $119.95 in campaign funds prior to filing a DOI with the commission. I got a motion. Is there a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye. Aye. Any opposed? Motion carries. Hopefully, when that matter gets shifted over to the Office of State Administrative Hearings, there can be some further discussion with her. And I would ask you to, continue to try to reach out to her.
I will.
We have that 30-day window. So, maybe this will, get her attention and have her reach back out to you.
Yes, sir.
Thank you, Mr. Badewell.
Question.
Oh, sure.
No, to you.
Oh.
Isn't there a way if no commissioner disagrees with the allegations that we can just take them all together?
So-
Just read them all in one motion? I mean, you're still gonna have to read all of them.
What I was going to suggest, Mr. Chairman, is, for example, 3, 4, and 5 could be one motion or the same statute, right? And you just specify that it includes 3 separate. But I think combining different statutes in one motion might potentially be more problematic.
We just had this discussion.
Right.
About this. Since we've been breaking them up since,
At least 3 or 4 years.
Yeah,
since the other case. I know you don't want to hear me talk that much. but
No, I
I'm
mean,
gonna break
it's
it up.
very soothing. It's like a nighttime
Okay.
story. I just,
Efficiency.
just trying to make things more efficient.
I appreciate it.
You're welcome.
We're off and
I'm
running.
going to call item 3C,
Shut down now.
which is case number 22-0175-C in the matter of Brad Owens. Mr. Knittel,
Good morning.
morning.
So this particular case, Mr. Owens was a candidate for the special Democratic primary election for State House District 129, which was held on December 20th, 2022. He qualified for that on or about November 2nd of 2022. He was unsuccessful in that election, which was then held. This came to our office via a third-party complaint that was filed back on December 20th of 2022, essentially alleging that Mr. Owens had raised and spent campaign contributions without filing any CCDRs, and that he not filed a personal financial disclosure report. The complaint was amended in March of 2024. I know there's a lot of time in between there. Honestly, this case just got, he didn't respond to some things and then kind of got left aside, so picked it up again to try and work through this. So he missed filings for December 5th and December 31st of 2022. Also did not file his PFDS as required after he qualified. And he also actually never registered. He didn't file a DOI in this particular case. The subpoena was done for campaign records with the return date. Mr. Owens finally reached out to our office. I believe the subpoena is finally what got his attention to do that. And we traded voicemails back and forth. Eventually, I was able to actually speak with him. He requested some additional time to provide the campaign records, which typically, if somebody's being cooperative, we want to get the records, so I agreed, gave him an additional 45 days to do that. And also, I provided him very specific instructions verbally and then also through an email, and I just put copies of the email later in the presentation so that he would understand how to file, to come and register. He indicated to me he had, he was saying his computer was too old and he couldn't do that. So I suggested public libraries, or we actually have a computer in the lobby of our office so that people can come file, and we have staff that can help them if they need, if they need technical help. None of those things occurred. After I sent that final email and spoke with him, I haven't heard from him since. So that's what brings us here today. So in this case, under 20 OCGA 21550, the main point with this is that he shall file with the commission no later than 15th day following the date of qualifying as a candidate as PFDS. That has never been done. This shows the date that he qualified. I know it's a little hard to read there. Normally I can expand it, but I don't think I have that ability here. But his PFDS was due 15 days, and that's never been filed. This is just a screenshot from our portal, and in putting his name, you can see there's no results found. I tried to find him every which way I could. He's not in our system. He just has never done anything. And so with the first violation is that he failed to file his 2022 PFDS covering calendar year 2021 violation of 21550. Next, related to 21530G. This relates to Mr. Owens having not filed a declaration of intention to accept any campaign contributions. He didn't do any of those things. Again, this is showing that there's been no DOA filed by respondent, because this is for a General Assembly House that will be filed directly with our office. These are some exhibits that I was able to obtain just kind of looking at, trying to search him on the internet and see what types of activity he had. So we can see that he at least has some spending. There is, you can see a sign standing behind him. That's an actual physical sign, as you can see. The one on the left, I'm not sure if that's simply something he put on the internet, but he does indicate yard signs are available by emailing him. And here's some additional actual yard signs related to his election, so there were funds expended on this. In this violation, he accepted and expended campaign contributions. I used the dates on or about November 2nd, 2022, and prior to the election, December 20th, 2022, in violation of OCGA 21530G. Additionally, he would have CCDR filing obligations. In this case, he falls under 21534C3. He was a candidate in a special primary election, and so he would need to file his first CCDR 15 days prior to the special primary. He did not make it into a runoff, so he did not have any obligation with that. As you can see, this is from our system. He's filed nothing, no CCDRs. And so he has two violations that are in this complaint of 21534. C3 and C2A, meaning he did not file his CCDR for December 5th, 2022, nor did he file one for December 31st, 2022. These are, I just wanted to show the commissioners, I believe He was given very specific and I think very detailed instructions how to go about registering, because he indicated he was having difficulty, didn't understand how to do this. And again, I encouraged him to contact our office at any time if he needed help, and he certainly had our number to do so. None of this occurred. He simply didn't follow up with this. So all in all, there are 4 violations that presenting to the commissioners today, as far as 21-550, 21-533, and 21-534. We ask you to find reasonable grounds that he violated this way.
I neglected to ask this just before you began your presentation, but is Mr. Owens present or anyone on his behalf present that you make any type of statement for him?
I don't believe so, no.
Okay. Does anyone have any commissioners have any questions for Mr. Knittel regarding Mr. Owens' case?
Did you do this PowerPoint yourself? Because it's very nicely done.
Thank you, I did. I know you enjoyed this PowerPoints
Yeah, I do.
for specific information, so yes.
Your PowerPoint and the chairman reading, it's a good day.
Let me, so I'm just summarizing all this. He basically ran a campaign and never filed with the commission at all.
Correct. I mean,
we
literally
haven't-
did nothing,
Nothing.
yes.
Okay.
And so records were, I don't have any records back because he hasn't responded other than calling one time and saying, hey, can I have additional time on the subpoena? I'll get those for you, and I have nothing. So I don't know what bank's at, or else I could subpoena the bank directly. I don't have that information. I will continue to try and work to get it because he told me in the phone call, he thinks he spent somewhere around $1,500. I can't tell you what the veracity of that is. That's simply his statement. But that's what he said.
Which ones of the 4 were the subject of the third-party complaint, as opposed to what was added in the amended complaint?
So the third-party complaint had the personal financial disclosure statement and CCDRs. The amended complaint was the DOI.
Okay. All right. Any other questions for Mr. Knittel? All right, I'll go ahead and, despite what Commissioner Thompson thinks, I'm going to go ahead and make my motions on this. I'm going to move to find that reasonable grounds exist that the respondent failed to file his personal financial disclosure statement for 2022 covering calendar year 2021 in violation of OCGA Section 21-5-50. I got a motion. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. I'm going to make motion number 2 for this case. Motion number 2 is that we find that reasonable grounds exist that prior to filing his DOI, the respondent accepted and expended campaign contributions on or about November 2nd, 2022, and prior to December 20, 2022, in violation of OCGA Section 21-5-30G. Got a motion, any second?
Second?
Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Motion carries. I'll move thirdly in this case to find that reasonable grounds exist that the respondent failed to file his special primary December 5th, 2022 campaign contribution disclosure report in violation of OCGA Section 21-5-34C3. Got a motion, any second?
Second?
Got a motion and a second, any discussion? Go ahead and call the question. All in favor say aye. Aye. Any opposed? Motion carries. Finally, for motion number 4 in this case, I'll move to find that reasonable grounds exist that the respondent failed to file his election year December 31st, 2022 campaign contribution disclosure report in violation of OCGA Section 21-5-34C2A. Got a motion, any second?
Second?
Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Thank you very much, Mr. Knittel.
Thank you, Chair.
All right, we're going to go ahead.
Look who's coming.
Didn't even wear his new shirt.
Who's here?
All right, we're going to go ahead and move to item number 4.
Did something just happen to the stream?
I don't know. I got a call.
It just went black on my laptop. Huh?
Your security clearance has been pulled.
Maybe it's not his last day after all, maybe it's mine.
Yeah, that's for executive session, I thought.
So y'all are certain we're still streaming? Okay, that's just me, y'all can go ahead.
Okay. Before we get started on item 4 on the agenda, I just want to go ahead and state in the way that we operate these now, is there anyone present who is intended to make any type of comment or anything of that nature with respect to any of the consent orders that are listed on, as item 4 on the agenda, A through T? Okay, hearing none, we're going to go ahead and go through Mr. Cusack's case. First one I'm going to call is case number 24-0029-C in the matter of Fannie Taifa?
Bonnie Willis.
Sorry, Bonnie Willis.
Yep.
Go ahead, Mr. Cusack.
And Commissioners, this is case 24-0029-C. This is in the matter of Fonnie Willis. This was a third-party complaint that came into the commission. It was filed by Congresswoman Marjorie Taylor Greene. There was 3 violations alleged on the third-party complaint. One stemmed from a 2018 PFDS from when Ms. Willis ran for Superior Court judge and failed to file a PFDS there. That one was barred by the statute of limitations. It had been 5 years since that filing was missed. So that's why that portion of the complaint dropped off. And then the one that was left was calendar year 2021, the personal financial disclosure statement, which was not filed. Elected officials are required in an election year 15 days from the date of qualifying to file their personal financial disclosure statement. And when it is a non-election year, they have to file it by July 1st of every year. So this one was a non-election year personal financial disclosure statement, which was not filed by that July 1st deadline. So this was a failure to file case, and in this matter, she failed to file the 2021 personal financial disclosure statement. She has agreed to a $625 fine. $125 of that is a late fee for failing to file, and then a $500 civil penalty. The maximum amount that could have been levied in this case was $1,000. So you had a little bit of benefit on the consent order, agreeing that she didn't do it, going ahead and handling your business and getting that filed. So that's the total penalty in this matter.
So can you explain to us, how the late fees go? Because I know there's several, just to remind all of us, I know there's several different late fees. It escalates over
Correct.
time. Like after 45 days, it's $1,000. And I believe there's some kind of, your guys' thought that we can't do that unless there's
It has to be
served.
noticed.
There has to be notice sent. Yes.
Just explain that a little bit.
Yes, so there is a mechanism for us to escalate the fines on a late fee. There has to be notice sent to, we have a template notice that in certain cases we will send out when we do audits of counties or the General Assembly for late fees. What happens is it has to be, I believe, certified mail to the candidate saying you have 45 days to pay this late fee, or else it escalates to, I think it can escalate up to $1,000.
Do we currently do any of that?
No, not at this moment in time. We haven't in a while, but we do have the template. We have a template for it, and
So we have a template, we just don't.
we have a template
We just
for
don't
it.
do anything with it.
No, we do send this out on local and General Assembly late fees, but most people pay it within that time period. Something like this is a little different because it came in as a third-party complaint, so we're not sending out a late fee notice. We're handling it as a case. So that's why it's a little different in this case than opposed to just sending out a late fee notice with the escalation.
And it's true, it's your last day, is that right? And this is gonna continue to happen for all your cases?
Technically, tomorrow is my last day, so.
Excellent.
And I'm fine with this continuing to happen for all of his cases. I will clarify one thing, though. Typically, as Mr. Cusack is talking about with those late fee notices, on the rare occasion that we do those are just late fees, right? Those usually aren't accompanied with a failure to actually do something required. So they don't become their own case. This is actually a case, and so it's in a different category of how we handle them.
And I'd say, too, this is a failure to file case as opposed to somebody actually filing something late. So it's different in that regard.
Okay.
Okay. Any other questions for Mr.
I
Cusack?
have 2. One, at least the version I have is unsigned. You have You have the signed version?
Yes, we do.
You mentioned there were 4 charges. As I heard it, you
3.
addressed 2. So are there 2 still pending, or were they rolled into?
So there was 3 total ones. I mentioned the one from 2018, and then it was sort of, I guess, if you want to treat this third-party complaint as a pleading, it was a pleading in the alternative, I guess, 2021 or 2022. It's calendar year 2021 that was missed. Calendar year 2022 was filed timely. So that's why it's only calendar year 2021 that was in this complaint.
Okay. And I didn't hear you on 2022?
It was like a pleading in the alternative. It was saying either 2022 or 2021
So
was
the
missed.
2022 PFDS covers the 2021 calendar year, so people get it confused a lot. They're like, oh, well, they missed the 2021 report about their 21-20 finances. And that's really the 2022 report, so.
This would have been her first year in office
Correct,
after, I mean, the election was in 2020.
correct.
No. Wait, sorry.
Yes.
Yeah.
I lived there. The election was in 2020. She won, so this would have been the one due on her first year.
First one she would have had due by July 1st.
Okay.
Right.
Gotcha.
Yeah,
So this is it.
correct, yes.
That was my rambling question.
All good.
And we do have the, there's a folder that everyone had with handout. There is the signed consent order that's in there, just in case anyone wants to review it. Hand that to
I believe.
Any other questions for Mr. Cusack on that case? All right, go ahead and proceed to the next one, 22 well, it's item B,
Item-
22-0023-C in the matter of Brad Barnes.
Yes, and this is case 22-0023 in the matter of Brad Barnes. This was on the previous agenda, which was continued. This case was previously heard at our most recent commission meeting, where Mr. Barnes had sent in a PFDS and was able to furnish it during, of course, the meeting and the hearing. Got with him after the meeting, and so we were able to get this consent order done, but he failed to, or didn't timely file his personal financial disclosure statement when he qualified to run for the General Assembly. So he had 15 days to file that personal financial disclosure statement, and I believe he ended up filing it about 10 days late. So he is paying $125 in his late fee for his failure to timely file this personal financial disclosure statement. He had run for the General Assembly twice in 2020 and 2022, and he was able to furnish his 2020 filing to the commission, in which he had timely filed that as well. So he is paying a $125 late fee and has since filed this report.
Any questions for Mr. Cusack on that matter? All right, we'll go ahead and move to 4C, Mr. Cusack. It's case number 22-0167-C in the matter of, is it Sheikh Rahman?
Sheikh Rahman, yes. This was a case that was heard during our Athens commission meeting, in which the commission found probable cause that Mr. Rahman had failed to file numerous CCDRs. Mr. Rahman, in this matter, was part of our legislative audit that we do every election year after the election is over, in which we go through and we make sure that every member of the General Assembly and all the challengers have filed their disclosure reports. We will be doing that again this year after the election closes, but
How do you know that?
The commission.
You won't be here.
The commission will be doing that this year.
Yes.
I don't
Just
know that the
creating work for
word
everyone.
"we" is a correct
You
qualifier.
won't be, you won't be here.
But I don't know, maybe they don't understand proper grammar in Roswell.
So, turning back to this case, Mr. Rahman failed to file 4 election year CCDRs in this case and has agreed to a $4,000 civil penalty. That may seem a little high, but also when we did our previous legislative audit in 2020, Mr. Rahman was part of that as well, in which he had paid a civil penalty. So this civil penalty is a little more because if you become a frequent flyer, it starts to add up. And I think it's one of those things we have adopted where if it's your first time and you're a first-time candidate, we're going to help you through these things. We're going to try to figure out a fair resolution your first time, get you some education. Here, when you keep messing up, when you keep doing the same mistakes over and over again, we're going to treat you a little harsher. And I think that's what this consent order bears out. So it's a $4,000 civil penalty. He has since brought on someone to file these reports for him, which I said was a good idea. And so somebody will be handling his reporting obligations for him, and he will be hopefully compliant going forward.
Any questions for Mr. Cusack on that matter?
I admire your patience on this one.
Thank you.
We'll move to item 4D. It's case number 24-0042-C in the matter of Brandy Reeves.
Yes, sir. Ms. Reeves was a candidate for Atlanta Judicial Circuit Superior Court Judge in the 2024 election cycle. This was a commission-generated complaint. She qualified for office during the March 2024 qualifying week. We noted that she had some campaign spending, website, she was accepting donations, some signs and things to that effect. I contacted her and she just oversight, she didn't understand the requirements, the legal requirements for running for office. But she suspended the donation link for her campaign. She quickly filed her DOI. She set up an account with our office. She was fully transparent and cooperative, provided a record of all the contributions she received prior to filing her DOI and all the spending. She provided some receipts for some spending that she made. She agreed she was in violation of 21-530G. She received $1,900 in campaign contributions. She spent $776.32 in campaign expenditures. She agreed for the violation to pay a civil penalty of $500. Position E, Mr. David Chastain, case 24-0043. This was a third-party complaint. Mr. Chastain's the current Upson County Tax Commissioner. He most recently ran and qualified in this election cycle, 2024. He agreed that he was in violation of OCGA 21-5-30.2. This is the statutory section that prohibits receiving contributions from a public agency. As the sitting tax commissioner in Upson County, he had an office stamp that was an official tax matter stamp that they use for mailings from the county. And the third-party complaint reported and cited mailings that he sent that were campaign-related for his run for office, and he used that official tax matter stamp. He responded to the complaint. He was very cooperative. He explained that it was just an error and that the stamp had been affixed to some of the mailings he sent out. He said it was only around 20 mailings that got sent out. He personally bought the postage. He had a smaller campaign just in general, so wasn't able to do a lot more digging. I don't know, we'll ever know how many envelopes actually went out, but it seems like a smaller violation and not large scale. For the violation, he agreed to pay a $500 civil penalty. Position F, Rochelle Robinson, case 23-0058. This was a third-party complaint our office received. Ms. Robinson's the sitting mayor for the city of Douglasville. She's held that position since being successful in the 2015 election cycle. She was just reelected back in the last year, the 2023 election cycle. She agreed on the following violations. She had a 21-5-34 C1B violation. She failed to file a June 30th, 2020 non-election year CCDR. Violation 2, OCGA 21-5-34 D.12. She had originally filed a $2,500 affidavit, and in April of 2022, she exceeded that $2,500. She was in between $2,500 and $5,000 at that point. The law required her to file a June 30th and a December 31st CCDR for being in that in-between area between the $2,500 and the $5,000 in campaign contributions. She acknowledged that she failed to file those two CCDRs. On CCDRs, she did file for violation 3, OCGA 21-5-34 B1A. That's just the requirement that you itemize all contributions over $100. She had two separate contributions totaling $5,000 that she failed to report or itemize on the appropriate CCDR. Violation 4, OCGA 21-5-34B1B. This is the requirement just to itemize any expenditures over $100. Ms. Robinson agreed that there were 11 expenditures totaling $8,300 that she failed to report or itemize on the appropriate CCDR. Violation 5, OCGA 21-5-33A. Ms. Robinson agreed there was what she explained is a mistaken double reimbursement, but essentially, she mistakenly took $1,500 in campaign funds that, she explained it was just a mistake, that she double reimbursed herself for a campaign expenditure. It was $1,500, and that violated the ordinary and necessary clause for campaign spending. Lastly, she had two violations of OCGA 21-5-50A1. She failed to timely file her calendar year 2019 and calendar year 2021 PFDSs. She agreed upon a late fee penalty of $625 and a civil penalty of $5,375 for a total penalty of $6,000 to resolve the case. Lastly, position G, John Christopher Neesmith, case 24-0050. This was a commission-generated complaint. Mr. Neesmith is a candidate for the Northern Judicial Circuit Superior Court Judge in this election cycle. He contacted our office. First-time candidate, and he's running for Superior Court Judge, and he overlooked the legal requirement to file a DOI before he started raising and spending campaign money. He called our office. He reported himself for the violation. He initially paid the $125 late fee for a missed PFDS filing. He was ready to tender payment for the civil penalty. I actually had to stop, generate the complaint, generate the consent, but he's already paid everything. He supplied financial records before I even had a chance to generate the complaint. So it was very unusual that he contacted us, and he was, before we even drafted a complaint, he told on himself. He agreed that he was in violation of OCGA 21-5-30G. He received $6,200 in campaign contributions, and he expended $5,796.41 in campaign expenditures prior to filing his DOI. He also failed to file his calendar year 2023 PFDS that's in violation of 21-550A1. He agreed to pay a $125 late fee, $500 civil penalty, total penalty of $625.
Are there any questions for Mr. Baywell on any of the cases? It looks like it's items 4D through 4G. I do want to make sure, and Mr. Cusack, first, do we actually have signed copies of everything with your three cases on the consent orders? All right. And Mr. Baywell, you have signed consent orders?
Yes, sir.
Okay. All right, we're going to go ahead and move into item 4H. Mr. Canelo, you've got a series of a few here.
Yes.
All right.
So this first case is case 22-0173-C. It's Carl Gilliard. In that particular case, that was a commission-generated complaint. The original complaint was done on December 20th, 2022. Then there was an amended complaint on May 15th of 23, and then some additional allegations on November 8th of 2023. Mr. Gilliard was represented by an attorney in this case. Mr. Gilliard this is related to his reelection to General Assembly, House District 162. He had been first elected to that seat in 2016. This is dealing with the 2022 election cycle. After the complaints were done and records were received, there were records for all of his banking, went through all of that. Ultimately, there were several violations that Mr. Gilliard had, and he agreed to in his consent. He failed to file 6 CCDRs from June 2020 to October 25th, 2022. He failed to timely file 3 CCDRs in the time period of June 30th, 2022, December 31st, 2022, and January 31st, 2023. He failed to file 3 personal financial disclosure statements and failed to timely file 1 personal financial disclosure statement. He failed to disclose expenditures of approximately $53,775 between the dates of January 1st, 2022 and December 31st, 2022. Within those, apart from failing to disclose those expenditures and going through all the bank records, there were improper use of his campaign contributions for expenditures that were not ordinary necessary expenses, which are also failed to disclose on the CCDRs. Ultimately, when the complaint was first made, it appeared there was approximately $54,000 that would be not ordinary and necessary. Going through the bank records and speaking with his attorney, it was ultimately agreed upon that there was $30,000 that he would be responsible for that were improper use of campaign funds. Those other amounts were readily attributable to legitimate campaign expenses, but not the $30,000. And so, in this particular consent, he agreed that he improperly utilized $30,000 in campaign contributions for expenditures which were used to not to defray ordinary necessary campaign expenses in violation 21-5-33A. That's in conjunction with all the other violations that I've mentioned already.
Mr. Kendall, you said did you mean $30,000?
I'm sorry, I misspoke. 30,000, I meant to say 30,000.
That was not
Yes, 30,000.
proper use. Okay.
Correct. Thank you for correcting me. The consent that was agreed upon is that Mr. Gilliard was to pay a civil penalty of $17,000, and I'll let the commissioners know that has already been paid as of today's date. He also agrees to personally refund his campaign account $30,000. He has been given additional time for that due to needing to gather those funds in order to do that. However, he agreed with his consent. The reports are getting done. He has also, I believe, has a new accountant to help him at least get his reports done. But so the penalty is, I think, fairly substantial, but this case, I think, required a substantial penalty because it was fairly egregious as far as the amount of money that was used.
And Mr. Kennett, I'm sorry, go ahead, Mr. Vice Chairman.
Is it true this isn't your first time presenting consent orders?
That is true.
Do you remember the former Commissioner Darrell Hicks? And do you remember his rules on the consent orders? That we're looking for them to go kind of like just by the numbers real quick?
My understanding of the Hicks rule, Vice Chairman Thompson, is that applies to dismissals, but it could be with consents as well.
No, dismissals, administrative dismissals, we don't do anything about it unless the commissioner pulls it off.
Oh, that's right. There's one vote at the end. That's
Wait,
right.
yeah, what do you say?
That's
No,
the-
There's no vote.
That's
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 the
the
rule.
Hicks rule.
That's the Hicks rule.
was the vote.
Well, I don't know. Somebody
So
have
now
a rule.
we've clarified the
Can
Hicks
we get
rule.
back to that rule, please? Because we see the consent order, we understand it, just hit the highlights, please.
Those were the highlights because there were a lot of bank records.
Highlights.
So moving on to the next
I will say,
consent.
this one's a little deeper than our typical one.
Yeah. And actually, I did have, so to clarify, because it's in the consent order, Mr. Kniddle, I don't think you said it. So he's paid the $17,000 civil penalty. The $30,000 he has to pay back to the campaign. How long does he have to do that?
Till the December 31st, 2025.
A year and a half?
Yes.
Okay.
And I don't know if he's going to make payments or one lump sum, but he has until that time period, and we will send reminders. So, moving on to the next consent, it's case 24-0003-C. That's Lisa Cupid. She is the chairman for Cobb County Board of Commissioners, first elected in 2020 cycle. In this particular, there were a series of Cobb County cases that we had due to an audit that we did of the county. In this case, Ms. Cupid, essentially, she was untimely in one of her CCDRs, a December 31st, 2022 CCDR, and she had accepted excess maximum allowable limits from 3 contributors for the 2020 election cycle. In that amount, total amount she accepted in excess of what she should have was $5,800, so rather minor amount. She had a rather large campaign, and she promptly refunded those. She immediately provided me with records once she received the complaint, so this got resolved rather quickly, and the records were very well documented. Next case is case 23-0065-C. That's Delana Lynette Lafferty. Ms. Lafferty was a candidate for Cobb County Board of Education, post 1 in 2020 cycle. Essentially, Ms. Lafferty, she was a first-time candidate. She failed to file her December 31st, 2020 CCDR report. And once again, she was very responsive once the complaints went out to her, and she agreed to the consent in the amount of a $125 late fee in this particular case. And she raised a rather minor amount of money. I think she raised about $400 for her campaign. So it was a little bit lighter on just the late fee. Next case is case 23-006, Matthew Sears. He was a candidate for Cobb County Board of Education, post 2 in the 2022 election cycle. In this case, he failed to file CCDRs for the reporting periods of June 30th, September 30th, October 25th, and December 31st, all of 2022. And so he was very cooperative. He got those filed immediately once he was made aware that he needed to file those. Again, this is a first-time contestant, and so he claims he didn't understand how to do that, but he responded rather quickly and took care of all this. And he agreed to pay $125 as a civil penalty and a late fee in $125 for a total amount of $250.
And I may have
Yes.
heard you wrong, but I thought that you said that case was 23-006. It's 0066.
It is, apparently. I'm trying to go through these faster than what I should.
It's fine. I just
So
want
I'll
to
slow
make
down.
sure we've got the right.
23-0066-C.
Okay.
Somebody watching the YouTube channel texted me and said, I need to get it like a 30-second timer. It was their suggestion, so.
And their name is Rick Thompson.
No.
And they have the same phone number as Rick Thompson, and they texted him themselves.
I am not gonna call out the person, but
The next case.
All right, let's go to 4L.
Next case is 24-0046-C, in the matter of Michael Brown. Mr. Brown was, he was a registered lobbyist on behalf of Cigna Healthcare from February of 2014 until July of 2023, July 30th of 2023. And thereafter, he became a lobbyist on behalf of Elevance Health, which is doing business as Anthem, that we may recognize that. During this time, he's been subject to all the rules. In the present case, essentially what he did is he did not, he failed to register as a lobbyist on behalf of Elevance Health and its affiliates, which is Anthem, prior to engaging in lobbying activity on behalf of them between January 7th, 2023 and March 23rd, 2023, in violation of 21-571B. He agreed to pay the commission a $250 as a civil penalty in this case, and that's the nature of that case. Then last one I have is case 24-0053-C. It's DeFonzio Daniels. The respondent in this case was a candidate for the Georgia General Assembly House District 180 in this 2024 election cycle. In this particular case, he accepted campaign contributions and made expenditures prior to filing his DOI in violation of OCGA 21-530G. And he agreed to pay the commission a $350 civil penalty for his violation. Just so the commissioners are aware, he had received approximately $350 in campaign contributions and he had about $1,600 of his own money in the campaign, so before he filed his DOI. Any questions on any of those?
Thank you, Mr. Kennedy. We're going to move to item under the consent orders 4N. Mr. McCarter?
fast.
Good morning.
Morning. Item N is 24-0035-C in the matter of Shadarin Fanning. This matter came before the commission pursuant to a complaint filed by Linda Kripe. The respondent was a candidate running for the position of Douglas County Sheriff. In this matter, respondent filed an affidavit not to exceed $2,500 in campaign contributions or expenditures during that election cycle, relieving him of the responsibility of regularly filing CCDRs. However, Mr. Fanning exceeded $2,500 in campaign expenditures in the run-up to Election Day for the office that he was seeking, and he failed to file any CCDRs, or at that time was just the January 31st, 2024 CCDR. Upon receiving the complaint, he was very cooperative, took full responsibility for his mistake, and claimed he didn't know that he couldn't, or he wasn't aware that he had exceeded that amount. He's very cooperative with our staff in resolving the matter, and he agreed to pay $250 in civil penalty. The next item is item O. It's two case numbers, but essentially the same case, 24-0034-C and 24-0039-C in the matter of Ben Paul Fremer. This matter came before the commission pursuant to complaints filed by Jason Shepard, and the commission itself filed a complaint. The respondent ran as a candidate for State Senate District 32 this past primary election season. Respondent filed his declaration of intent to accept campaign contributions and make campaign expenditures on February 21st, 2024. However, he improperly made campaign expenditures prior to filing his declaration of intent. Upon receiving the complaint, respondent reached out to us and explained that he was unaware that he couldn't make expenditures prior to filing a declaration of intent, but he was very cooperative, took full responsibility for the oversight. To resolve it, respondent agreed to pay $250 as a civil penalty. Next item is item P, 24-0005-C, in the matter of Rebecca Keaton. This matter comes from an audit of Cobb County campaigns. Respondent served as the clerk of Superior Court of Cobb County from election year 2012 until election year 2020. In this matter, respondent failed to file supplemental CCDRs for the year of 2021. In addition, respondent improperly accepted a campaign contribution of $5,000 during the 2020 election cycle, which was above the campaign contribution limit of $3,300. Upon receipt of this complaint, respondent contacted the commission and explained that respondent had been diagnosed with a brain tumor around the time of missing this report. And she provided a lot of evidence to that fact, provided affidavits from her doctor, even providing x-rays to me. So she was very forthcoming with all this information. Despite her illness, respondent was cooperative, took full responsibility for the oversight, and she agreed to pay $125 in civil penalty and $125 in late fee for a total of $250. And the next item is item P, 24-0021-C, in the matter of Nichelle Davis.
That's actually Q.
Oh, sorry, Q.
Okay.
Excuse me. 24-0021-C in the matter of Nichelle Davis. The matter came before the commission from that same audit of Cobb County campaigns. Respondent currently serves as a member of the Board of Education for Cobb County for Post 6. And in this matter, respondent failed to file 2 CCDRs within applicable filing periods. Respondent also failed to file her PFDS covering the calendar year of 2022 within the applicable filing period. And upon receiving this complaint, respondent took full responsibility, was very cooperative, In resolving the matter, respondent agreed to pay $375 to the commission in late fees. And the next item is item R, 24-0026-C, in the matter of Lawon Allen Jr. This matter comes before the commission pursuant to a complaint filed by Carol Yancey. Respondent currently serves as the sheriff of Clayton County, Georgia. In this matter, respondent failed to file his PFDS statements for the years of 2022 and 2023 within time periods. In addition, respondent failed to file 3 CCDRs within applicable filing periods spanning from 2023 to the present. Respondent immediately contacted the commission, took full responsibility for these missing reports, and pledged to file the missing reports, which I can confirm he has, as of today, filed those missing reports. He also promptly provided bank statements to me and was overall very cooperative with the investigation. And resolving this matter, respondent agreed to pay $625 to the commission in civil penalties. And the next item is item S, 24-0033-C, in the matter of Monique Sheffield. This matter came for the commission from that same Cobb County audit. Respondent currently serves as the County Commissioner of District 4 of Cobb County. In this matter, respondent failed to file her PFDS for the year of 2022, and additionally failed to file or filed late 6 CCDRs within applicable time periods spanning from 2020 to the present. And upon receiving the complaint, respondent reached out to us and took full responsibility for failing to file these reports, and in a timely manner, and assured the commission that all missing reports would be filed. And to resolve this matter, respondent agreed to pay $900 in civil penalties. Finally, item T, which was previously in the preliminary hearing section, in the matter of Craig Owens, 23-0048-C. And this arose out of that same Cobb County audit. Respondent currently serves as sheriff of Cobb County. He accepted campaign contributions in excess of max limitations during his past election cycle. And upon receiving the complaint, the respondent's attorneys reached out to us and were immediately very amenable to getting us everything we needed. He got us all his bank statements, and ultimately we came to a resolution of paying $6,000 to the commission for those 6 occasions of going in excess of campaign contribution limits. I think that's all I have.
Do you have any questions for Mr. McCarter? Just to check with the staff just one more time. We've got signed consent orders at this point on everything, right?
Yes.
Okay. Mr. Vice Chair, do you have a motion?
Chair? I move to approve. Is that what you're looking for here?
I'm just, this is the Hicks rule. I wanted to make sure that we got the, I'll go ahead. I'll do it. I'll make a motion to approve all of the consent orders, items 4A through 4T, as reflected on the agenda.
Did you want to read each one?
Second.
I got a motion and a second. Any discussion? Go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? All right, all of those consent orders are approved. Does anyone need a break? Everybody good? We'll go to item number 5 on the agenda, administrative dismissals. Mr.
I have
Oh,
something.
Mr. Cusack.
Well, I think,
So one way we could take, so I request that we remove 5A, 2018-0098, for more context of why it's being administratively dismissed, because it's a long-standing case. The other ones I'm fine with.
so as a reminder to the commissioners, the administrative dismissals are dismissed as operation of law in my signature, but as Mr. Thompson has done, he can remove it either to reopen it or to have further discussion about the case before any or no action. And that's what he's done at this point. So there's a motion.
Okay. You got a motion, any second?
Second.
Thank you.
Got a motion and a second. Any discussion? All in favor of removing item number 5A, which is case number 2018-0098 in the matter of Donald Kenneth Balfour?
And to clarify, Mr. Chairman, to remove it for discussion, not to
Yes, that's
reopen it,
correct.
because those are both options.
Correct. I guess we'll just consider that to be, tell you what, do we just need to do a new motion? All right. I'll go ahead and call the question. All in favor, say aye. Aye. Any opposed? All right, Mr. Cusack, you going to provide a discussion on that?
Yes, and I think it's interesting to go back, or it's imperative to go back from the beginning on this case. So what happened in this case is Mr. Balfour served in the state Senate for a fair amount of time and left office in 2015. So his last actually election year report for when he actually was defeated in his reelection bid was December 31st of 2015. And from that point forward, he had not filed a disclosure report, even though he had excess contributions at approximately $630,000. So the context there is the last report that's been filed is December 31st, 2015. On August 18th of 2018, the commission received a third-party complaint stating Mr. Balfour hadn't filed since that report in 2015. And he had engaged Mr. Chalmers as his attorney, and Mr. Chalmers cited to numerous or court cases that it was actually some case law, that's bad case law for the commission, in which when there is a failure to file a report, so since Mr. Balfour didn't file these reports, the statute of limitations at this time was 1 year based on what's called the informer statute. There was a case out of Fulton County. It was Pitts et al., the State Ethics Commission, Civil Action 2010 CV 181808 in Fulton County Superior Court, which stated that there is a difference between a failure to file and a late filing. And the late filing was a 3-year statute of limitations because this was a 2-year office, but a failure to file because the statute was silent on the filing was a 1-year statute of limitations. So the statute was written to where the statute of limitations only kicked in when there was a late filing. It was silent to the failure to file. So the rule of lenity applied, and it went to that 1-year statute of limitations. So Mr. Chalmers asserted that defense, said, we don't have any more campaign records, we're not required to keep them, which he was correct on, and that there's a 1-year statute of limitations on this. That statute has lapsed. The commission is out of luck here. There was some discussion, I believe, in 2019 around this case, and the question was posed to me, why don't we subpoena every bank in Georgia for these records? And we just didn't have a good faith basis to actually send a subpoena to every bank. So we had no idea how to recover these records, how to recover these documents, figure out where this money went.
And to clarify, Mr. Cusack, correct me if I'm wrong, but Mr. Chalmers represented that the campaign account as of 2019, when this discussion was ongoing, at that time, his assertion was the campaign account was closed, there was no money in it, and they had disposed of all campaign records that he said they no longer had to take care of, and he was correct based on the statute.
Yes, he was
So-
correct on that.
So we don't even know that we don't know that there would even be money in a bank if we
Right.
magically figured out what bank it was.
Right. So we're sort of out of luck of just trying to figure out where this money went. The only good thing I would say, we hate the result of this case, hate that we're having to dismiss it and not able to track the money down, but there is some good that has come out of it in that we have, since, as an agency, Mr. Amati petitioned the General Assembly to rewrite the statute to include the statute of limitations for a failure to file and also a late filing is 3 years. So that case law no longer applies here because the statute has been rewritten to include a failure to file and a late filing. So that is the good. I hate using legal loophole, but that's essentially what was created here. The rule of lenity put it in the respondent's favor, but that has since been closed. So now, if this case were to happen today, they would be having to turn over these records. So this case brought upon a law change that's ultimately good for the agency in tracking down records like this. So this situation, this type of case, wouldn't happen again. And we would be able to track the money. So that's the good that's come out of this case is the statute is rewritten, so this situation won't arise again. But I think it's important to talk about this case and what's come of it, as opposed to just saying, oh, that's just the state of law, we're going to live with it, we went and changed the law.
the respondent nor their attorney provided any kind of details where over $600,000 went? There was no voluntary trying to,
I asked,
explain anything?
I asked and I was
They were
told,
just-
I don't have to
they were
tell you.
just- Okay.
So,
And I will clarify, from the commission standpoint, no one's happy about this result. I want that to be crystal clear. This commission actually reopened it and we took another run at it. Unfortunately, there's just no way within the constraints of the law at the time to find out. And we're not going to move beyond what the law allows us to do. Everyone's unhappy with this result, but that's what the law was at the time. So we changed it to make sure this doesn't happen again. But we have taken every look at every angle
Yeah.
at this, and this is just the reality that we're in.
I think I went back through about 15 years of disclosure reports trying to figure out a bank account I could get into or subpoena, and there's just nothing there, so.
All right. Anything further on administrative dismissals? We'll go ahead and move to item 6 on the agenda. It's a rule for consideration. Mr. Kniddle, are you handling that?
Yes.
I wish I knew.
Before, I guess we get into the guts of the thing, have we, as the commission, received any written comments on the proposed rule?
No, we have not.
Okay.
Controversial though it may be.
Well, I understand, but I mean,
This rule
I've got
was-
to make sure that that's the case, so I just wanted to.
How does the
wanted to
Chevron
confirm.
doctrine apply to this one?
Right.
We want to point out that Mr. Cusack drafted this very complex rule change, and we appreciate his work on this.
All right. And there's no one present for any, any verbal comment, again, for record purposes under how the rules are supposed to be, the
Correct.
process we have to go through, in other words, for amending these rules. So go ahead and proceed.
Thank you. So the purpose and main reason of this rule is to essentially to correct the name, because as we all know, the legislature has, I guess, reverted our name back to State Ethics Commission. And so the proposed rule is Rule 189-2-.09 for civil penalties imposed by the commission. It will, the previous language has been struck through, and the new language will read, all civil penalties imposed by the commission shall be made payable to the State Ethics Commission, and such funds shall be processed pursuant to the Georgia Government Transparency and Campaign Finance Act. Essentially, it's just correcting the name as to the payable party. We'd ask you to adopt that.
Any questions for Mr. Kniddle?
I do have one. Is this the only place in the regs that we need to make this change, or will there be more?
Uncertain, there may be additional, we'll do a full,
I wouldn't be shocked if there weren't.
there may be occasional one that pops up, but we'll do a
Mr.
review.
Cusack just he's been cruising, so he hadn't been blacklining.
Yes.
I asked that question this morning, and I was told that there aren't any other places,
well.
but perhaps that's not correct.
Perhaps there aren't any, but
Okay.
I haven't gone through it myself, so I can't tell you with 100% certainty.
All right,
I'm sure Mr. Cusack has, though, so.
all right.
Well, I will move to approve it.
There you go. Got a second? I'll second it. Got a motion and a second. Any discussion? All right, all in favor say aye. Aye. Any opposed? All right, that rule will be amended. All right, I'm not sure who to turn over this next item on the agenda to, but I think it's going to be Mr. Vice Chairman.
No, I have a question before we go
Oh, sorry.
to go to 7, because, so, and maybe it's Mr. Kuzak or Mr. Kniddle or whatever. There has been a lot of conversations, because there's no longer a place for commissioners to ask questions on the agenda. There used to be, just saying. Now it's off. But anyway, there's been a lot of questions and stuff about, what's the staff's, and maybe this is you, Mr. Muddy, what's the staff's opinion when a vendor for a campaign doesn't get paid? Is that just a contractual thing where they have to go? Is the campaign committee supposed to report it as, because we did away with deferred expenses for whatever reason? What's the, because I know you guys have had this question, but it's unclear to the public.
So I think it depends on which context of this comes up. I know I have a current case right now where this has come up and there's an actual contractual dispute over what work was done and the replacement costs of bringing in another vendor. I think it's muddy waters for the commission to wade into when there is a contractual dispute and there's legal filings on that. I think it's a wait and see approach of what needs to be reported once those legal wranglings shake out. Now, if there is a vendor.
I'm gonna stop you for just 1 second, because I don't want this, you know, if we handle this kind of matter the way that this is being handled with a question from the commissioner to staff or whatnot, you know, we're getting awful close to an advisory opinion on this.
Right.
And I don't want something, you know, to be said, you know, during this, you know, informal conversation that we're having right now that, you know, that the commission is then gonna be bound to, when in fact there hasn't been a full study, you know, of what the applicable law might be. So, you know, I'm just not sure that this is the proper context in which to handle this matter. I think, and again, I'm not trying to disagree with the procedure or anything, but I think it's something that, you know, may be handled between commission staff and a commissioner if they have a question. And then, you know, as a case pops up, or, you know, if we feel like we need to do something more formal, then we do it. But
Right.
I'm just not very comfortable with this situation. We're asking very general questions, which, you know, then the commission's gonna be bound to in some form or fashion.
And it probably is a better avenue for an advisory opinion. And I think the situations that arise are so different, or in each case is unique, that it might be ripe for an advisory opinion.
Well, I mean, that, and on top of the fact that you've already said that you've got a case right now where that's gonna be an issue.
Right.
You know, again,
Yeah,
I don't.
Potentially. but yeah.
Potentially, yeah. And yeah, it's, probably best to,
And Commissioner Thompson, I am not trying to shut you down. I just don't wanna.
You did shut me down, but that's okay.
All right.
That's your job.
All right, let's go ahead and move to item number 7 on the agenda.
Don't sit down, Joe.
Again, am I turning this over to you, Mr. Amati? Okay, Mr. Amati, go ahead.
So if you're following along, and you haven't yet figured out that Mr. Cusack's last day is soon, you haven't been following along very closely. So Mr. Cusack is our deputy director, obviously, and tomorrow will be his last day at the commission. He's been afforded a wonderful opportunity, the city of Roswell, which he's going to be taking, and it's a wonderful opportunity for Joe, for Joe's family. I think everyone here is happy for Joe and his family, and not at all bitter. I know the vice chairman and I certainly aren't. But we wanted to take a moment. I'll let anyone say what they want, but I wanted to take a moment to recognize you and to recognize Joe's work on behalf of the commission. I met Joe about a decade ago. Mr. Knittel and I actually plucked him out of law school, and we hired him in the DA's office at the time. What a mistake that was. But Joe has been with us through thick and thin. He was one of the first hires I made over here at the commission. He's been a trusted ally and advisor, and he's done a phenomenal job representing the commission and on behalf of, I think, the people of Georgia throughout his career. And so, Joe, we just have a little token of something that we wanted to present to you for your years of service. And it is, and I'm going to be real honest, I did not pick this out. All credit goes to Katie, but it's a very nice sort of crystal clock with an engraved inscription recognizing you and your service. And I just wanted to say, man, thank you for everything, and I'm proud of you. So come on up here and get this, and then get out of my face. I'm done with you.
I thought you had a sticker to go on there that said quitter. It's supposed to be a sticker.
I was leaving that to your time.
We will.
Yeah.
We will. We'll.
All right. I don't know if anyone else.
Hey, listen, I mean, he's coming to Roswell where I live, Roswell, America, so I'm good with it.
The only thing that I'll add, Joe, is, you know, working with you over these years, I mean, it's been great. I think that there have been, you know, substantial strides that have been taken to get this commission, you know, back to the level that it should be. I think that you have played an incredibly large role in getting the commission to, you know, where we are today. So again, I want to thank you very much for all of your service.
And you're the only staff member, I believe, in my recollection, that has literally got in an argument with a commissioner and started being very mean to them, just so you know.
I think we will all remember that. So, again, Joe, we wish you the best of luck. Stay in touch with us, and I don't want to see you, change your mind about representing the city of Roswell at some point. And we actually look up and see you standing up there representing, some of this and using all this knowledge, information, and time that you've been given here to represent, to make arguments against us, okay?
Look, I'll petition the legislature to specify Joe Cusack cannot represent anyone before the commission. I'm not above it.
All right, again, thank you very much, Joe. Best of luck. We'll go ahead and move to item number 8 on the agenda, which is the report of the executive director. Mr. Amati.
Thank you, Mr. Chairman. So I'm going to update the commission on a couple legislative bills and priorities and things we were tracking during session. First, SB 368, which is commonly referred to as the state version of the FARA doctrine, the Foreign Agent Registration Act. SB 368 was a priority initially of the Secretary of State, and several senators consulted with their office and became a priority of the Senate and passed. The House also passed, and the bill was passed by the General Assembly. Conceptually, FARA, a good idea. We're in support of it conceptually. There were unfortunately some things that were maybe not included, that were oversights during the legislative process. And so 368 was ultimately vetoed by the governor out of concerns from the business community and some folks about whether this would have been far more overreaching than it was intended to be. That being said, I do believe 368 will be back in January. I believe we'll be involved. I've told the Secretary of State's office we're happy to be involved continuing with that. And I think, this version will have the appropriate exceptions that the federal statute does, and I do expect this to pass in the coming session. SB 358 was an omnibus ethics bill that some senators and we spoke about that they had interest in. This did pass the Senate. There were some amendments throughout the Senate process, and by the time it got to the House, there were some other amendments. Ultimately, this bill fell short. I think more so just because there were enough changes that no one was comfortable knowing what the final draft and agreeing on what that was. But I think this is another one that will be back, and I'd be very surprised if portions of 358 don't get passed in the coming General Assembly. And third, HB 968, which dealt with generative artificial intelligence. This is something that Representative Brad Thomas carried and worked with us closely on. This is an important issue. AI is developing far more rapidly than I think anyone, well, not anyone, but most people projected, and the impact it is going to have in all aspects of life, including politics, is a very real and significant one. This one fell short in the Senate, but again, I've had enough conversations. I think this one's coming back and has real legs. So all three of these I know we've talked about. I know they either didn't pass or got vetoed, but these are three bills that I think will be back and are something that will be something we need to prioritize and follow. Last thing, I'm going to actually just unilaterally change this budget. I'll do that next meeting. I'm going to change that to a staff announcement. I'd like to announce that we do have a new deputy director now that Mr. What's-His-Name is gone. And I'd like to recognize Mr. Knittel, who has been with us for a couple years now as a senior staff attorney and will be sliding into that role as deputy director and general counsel. And so welcome into the new role, Steve, and we look forward to working with you in that position. And Mr. Chairman, that's all I have.
Ms. Young, we'll move to item number 9 on the agenda. Do you have any report from the Attorney General's office?
Just a very short one. All is quiet on the litigation front. We're just waiting on orders in our appellate cases, and no idea whether we'll be able to report anything other than we're continuing to wait next meeting, but eventually we'll get an order from them. We've got several cases calendared at the Office of State Administrative Hearings. I guess I'm going to have to see if Mr. Knittel will be able to attend those as our witness with the changeover. But those, we're hoping to have several more getting calendared throughout July and August. many of those settle after a hearing notice is issued with a consent order, but hopefully at least one or two of those will make it all the way to the hearing and result in some orders for you for next time. Thanks.
How many cases are over there now that are waiting to be calendared?
We've got 2 on the calendar and I think 3 or 4 more that are in the pipeline.
Are any waiting to be filed over there at this point?
Yeah, we've got a backlog of a number of cases. We've got 3 or 4 vacancies in our section right now, which is, we need to discuss more on staffing issues. We can probably do that in an executive session, but I'll just tell you that, especially with elections going on this year, things are pretty tight in our office. But we're trying to pipe them through to make sure that we get, keep them going over that way.
And where are the again, I want to make sure that I'm up to date on this. Where are we waiting for orders at this point?
We don't have any that we're waiting for orders. Everything that has been already filed is either set for a hearing or ends up getting resolved by a consent order.
It was a very poor question on my part. I meant like the appellate decisions that we're waiting for and,
Yeah, we have 2 of them. One's on the Libertarian case in which they were in the 11th Circuit challenging the difference between political parties and political bodies. The other one being the New Georgia Project case that involves ballot committees and independent committees in the 11th Circuit. Hopefully we'll get
We had oral
orders on
argument on
those.
that.
I'm sorry?
We had oral argument on that a little while
Yeah,
ago, right?
they've been oral, both of them have been through oral argument, and we're just waiting for the 11th Circuit to write an opinion in their due time. I would say it usually takes them about a year from the date of the oral argument based on the ones that I've had go through in other cases.
okay.
Thanks.
Thank you very much. Has anyone signed up for public comment? I'm assuming no. Okay. I guess I'll move that we adjourn into executive session. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. We're going to, I guess, temporarily adjourn the meeting at this point and go into executive session.
Correct.
And I'll make a motion to exit executive session. Do I have a second?
Second?
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion passes. I'll take us to item number 12 on the agenda. Today was a very, very efficient day. Was there anything else from the commissioners? All right, I'm going to go ahead and move to adjourn. Do I have a second?
Second?
Got a motion and a second. Any discussion? Call the question. All in favor say aye. Aye. Any opposed? All right.
The gavel?
I do want to thank, everyone with the Whitfield County Courthouse, by the way, who provided any assistance or anything today. I should have said that at the very beginning. of the meeting.
Commissioners and, yeah.
Right.
Yeah, this was wonderful. Thank you so much.
Thank you.